Hi everyone, this is Dr. Victoria Nale, and here with me we have two presenters, including Miss Cynthia Opakas and Miss Karen Miss Karen Nakagwa. So in today's webinar, they're going to discuss their book chapter, which is titled Arbitration Practice in the Energy and Mining Sectors in East Africa. This is part of the arbitration book series we're hosting from the book project titled International Arbitration in the African Energy and Mineral Sector. And this book is edited by Dr. Victoria Nalole, myself, and Professor Damilola Olawoye. So we're going to have a few minutes for our presenters to take us through their book chapter. What do they mean by arbitration practices in the energy and mining sectors in East Africa? What are the key issues and what are the recommendations from their book chapter? But before we start, I would like Cynthia and Karen to briefly introduce themselves. I'll start with you, Cynthia. Could you please introduce yourself?
Thank you. Thank you so much, Dr. Nalule. My name is Cynthia Opakas. I am an associate in the Dispute Resolution Department at OK Law LLP in Nairobi, Kenya. I'm also undertaking an LLM in International Energy Law and Policy. So I am working towards merging the practice of dispute resolution and energy and extractives as well. I'm also a fellow of the Chartered Institute of Arbitrators, and I look forward to this engagement.
All right, thank you very much, Cynthia. I think there are lots of things we need to know about you, but let me go to Karen. Karen, first, I'm sorry I mispronounced your name, and yet you are from the same tribe. So Karen, would you like to introduce yourself, sell yourself, tell us about your profession background?
My name is Karen Nankwanga. I am a lawyer and an advocate of the High Court of Uganda. I am an energy law practitioner and a project management specialist. I am currently the program coordinator for the RCEF Energy Fund, funded by the UK government at Cambridge and the Peterborough Combined Authority. I am also undertaking an LLM in International Energy Law and Policy, and my interests are in renewable energy, climate and energy practice, as well as arbitration.
All right, thank you very much, Karen. Cynthia, anything else you left out? Because you're a very experienced advocate from Kenya, but anyway, we shall start with the discussion for you to give us a brief background about your book chapter. What exactly do you cover in this book chapter? What are the key highlights? And for the viewers out there, what should they look out for? Because this is just a summary. I know your book chapter is a very long chapter, but just a summary for them if they're to buy the book and also to buy the chapter. What should they be? What should they expect? So I'll leave you to start off with the discussion. Thank you.
Thank you. Thank you so much, Dr. Nalule. Our book chapter basically focuses on the practice of dispute resolution generally, and specifically arbitration in the energy and mining sectors in East Africa. We see that arbitration has emerged to be one of the most, if not the most preferred dispute resolution mechanism in East Africa, and that is why our chapter focuses majorly on arbitration. So we are just going to give brief insights on what we discuss in our chapter, and of course, people can look out for that. So on this first slide, we see why this basically has like 6 points that we majorly discuss in our chapter. And the first thing we discuss is why arbitration has emerged to be very popular and the most preferred dispute resolution mechanism. And that is because, if we could just go to the next slide, please. That is because, number one, of the flexibility and the flexibility that arbitration provides. So in arbitration, parties have the chance to choose who the arbitrators are. But that is to note that usually there is commercial arbitration and there is investor-state arbitration. So most of the energy disputes where you have international investors will prefer to go for investor-state arbitrations, which tend to be institutional proceedings. So that means that the proceedings are managed by an institution, say ICSID or ICC or the LCIA. There's still flexibility in these proceedings because each of the parties, whether the state or the investor, will have the opportunity to appoint an arbitrator, and then both parties jointly appoint a chair or a chairperson. Or when they're not able to agree, then they can seek assistance from the institution. So still there is a level of flexibility, which is a very big advantage in arbitration. There are two other advantages which are listed in literature as having been. Sorry, Karen. Sorry, I'm still on the previous slide. There are two other advantages, which is cost and expediency, which are still listed as advantages. But practically speaking, this is debatable because the cost, especially investor-state arbitrations, can tend to be quite expensive and not. Well, they could be expedient, but just the process of arbitrator appointment could in itself just take months. So those two advantages are debatable. Confidentiality is obviously an advantage that arbitration offers as opposed to court processes, as well as neutrality. And one of the other advantages that arbitration offers is the element of finality, that there are not too many tiers of appeal as would be in court processes. And finally, there is the enforcement of awards. Arbitration has sort of clear-cut enforcement mechanisms, which investors or government would be keen to know that once we succeed, we could simply just enforce our arbitration, our award. It's important for parties to check that the countries they're investing in, or that state parties, for example, to the New York Convention on Enforcement, which makes enforcement quite easy. Karen, if you could go to the next slide, please. Yes, so I have mentioned that a lot of energy investments by international parties in energy and mining in East Africa is by foreign investors. So there is a regime of international law, which is investment law, that governs foreign direct investments or FDIs. So under investment law is a critical part of law, of international law, that we need to consider in arbitration, because it sort of has the substantive tenets that usually are applied to investment disputes. So what investment law pretty much does is it sets out the standards of treatment that investors should be accorded when they invest in foreign countries. So when you read the chapter, you'll also see we delve deeply into the rule and the standards. We discuss the fair and equitable standard. We discuss the protection and security international minimum standards. We discuss all these standards in detail in the chapter. Karen, if you could go to the next slide, please. Yes, so I have mentioned most of this, that international arbitrations could either be commercial or investor-state arbitrations. The only thing that I need to mention is that, of course, governments cannot come and rely on national laws or municipal laws to override their treaty obligations in investment law. Basically, that's basically it. And I think I've mentioned everything on this slide, and I'll leave Karen to take on the next slide.
Like Cynthia mentioned about the importance of investment in energy and mining, this is because, like, we know the case with East Africa is East Africa is endowed with a vast majority of minerals and energy potential, and the ability for governments to finance the development of these sectors is very minimal. So they tend to seek out foreign direct investment, and they also tend to seek out private financing through private investors in order to develop these resources and to develop their key sectors. And this is because the governments understand that energy and mining plays a very critical role in the development of countries, in the development of their social and economic standards for their communities and the populations. And as more and more investment, or as more and more players are being introduced into energy and mining, we are going to see so many issues that emerge and so many trends that emerge. One of those, we have the rights of indigenous communities and access to justice. Energy justice is a very key component that is being brought forward in terms of how do we structure these projects and how do we deal with the rights of these indigenous communities, because these local communities are affected by these investments and the projects. And in our chapter, we delve into some of the few scenarios that we have experienced, for example, in Tanzania and in Uganda with the establishment of the East Africa crude oil pipeline. What happened to these indigenous communities and these people that were being forced to be moved out of their homes, and that later filed lawsuits against governments and these private investors? And that is something we look into in our chapter. We also look at commodity pricing and price volatility, and this is witnessed mainly in the oil and gas and mining sectors. And this affects the commercial viability of these projects and subsequent decision making within the sectors. And this can be potential ground for disputes or challenges, and how best placed are these governments and these individuals in handling these disputes that could potentially yield into mining and energy cases. We have local content regulations. Like we mentioned earlier, the governments are understanding the value of oil, of mining and energy projects to the development of their economies. And because of that, they want to bring on board more of their locals to participate in these various activities, and are enacting laws and local legislation that requires these investors to potentially source products and source labor from these local communities. But this has a vast impact on the outcomes of these projects and the confidence that these investors have in terms of how certain are they that the local communities can actually provide them with the support that they need. And you have a nexus where you have local legislation conflicting with international business standards, and this yields potential ground for arbitration and for disputes. And we have government control of resources and the contractual models. Most of these resources are state-owned resources, and this is in line with the principle of permanent sovereignty over natural resources. So these governments seek out to ensure that they get the best out of these resources. And because of that, the contractual models adopted also adopted and created to create a mutually beneficial relationship between these investors and the government. You have production sharing agreements that have a split for how production rights and obligations are envisaged between the parties. And when it comes to energy, you have the power purchase agreements. These come with a whole new dynamic in terms of how you structure the contract, how you structure the terms, and also how do you approach the needs and benefits of these different parties. And this can be potential ground for dispute where these particular clauses are not drafted to meet the needs of the various players within these agreements. And then we have transparency and accountability, and this is key, where we have the energy and the mining sector having the greatest potential for corruption at various stages, right from the development up to the final production stage. And this creates room for illegalities and challenges. And so because of this, we have seen cases, and these cases are highlighted within our chapter, in Rwanda, in Uganda, in Tanzania, where governments tend to withdraw these rights from these investors because of illegalities. And all of this has enabled the growth of energy arbitration and arbitration cases to grow within the region. And we also have the power of the tribunals to grant interim reliefs. And this we are looking in terms of the local tribunals and how at the local and international tribunals, most of these cases, as is highlighted in the chapter, are had at a level that is out of the region. And most of these people do not understand what it is that is affecting the people within the East African region. And so we delve into the power of these tribunals to pass decisions that then have an impact on the East African community. And then we also look into the evolution of arbitration centers. We have various arbitration centers. We have the KISC, which is the Kigali International Arbitration Center, ICAMEC, which is the International Center for Arbitration and Mediation in Kampala, SEBAC in Burundi, and the NCIA in Nairobi. And all of these arbitration centers are emerging. Do they have the potential? Do they have the ability and the capacity to handle energy and mining issues? Among the recommendations that we make is we need progress in terms of the number of cases that are had in arbitration centers in East Africa. Arbitration centers in East Africa are growing, and majority of them, as Cynthia mentioned, of these cases arise out of investment and commercial obligations. We need progress in terms of cases arising out of energy disputes, because energy is a whole new dynamic. Energy is a whole new ball game altogether, and we need people that understand the dynamics of and who understand the dynamics and the impact that these energy and mining cases have, so that we can isolate the energy component out of these cases and shift focus from the investment and commercial perspective. The centers also need to be equipped with better laws and deeper knowledge entailing energy and mining. And this goes back to how you build the human capital, the human resource capital, to be able to hear these cases and create legislation that can be tailored to the dynamic of energy. We need, and this we've mentioned as well as highlighting the need to shift legal elements and requirements of international energy and mining arbitration, move it away from the commercial and investment arbitration sections, because it gets lost. The component gets lost in translation, and we have decisions that are feasible in terms of commercial and investment ventures, but may not be feasible when you look at the dynamics of energy and mining. We need to create special dockets that cater to the unique nature of energy and mining. We need sector-specific building so that we have people within the sectors to understand the resource governance, utilization, and regulation of these different fields of energy and mining. And this enables these key players and these key people to participate in these arbitrations, because they are able to be equipped and have the knowledge and understanding. And we also need to encourage the incorporation of energy-based charters, such as the Energy Charter Treaty, to develop capacity to train people to understand what it means to arbitrate in terms of energy. And that is all we have for you today. And we would encourage you to keep looking out for our book chapter and look for the book. It has so many insights into how we can improve international energy arbitration and grow the field of international energy arbitration as the sectors continue to grow within the East African region.
All right, thank you very much, Karen, and thank you very much, Cynthia. So I see we have a few attendees. We have Kato, Justus, we have Leonard. Do you have any questions for the people who are attending? Do you have any questions with respect to the presentation made by Cynthia and Karen? Justus, any questions from you? Oh, I have to allow them to talk. All right, it seems we don't have any questions, so I'll ask just one follow-up question. What do you think can the East African countries learn from the developed countries with respect to arbitration, especially energy arbitration? Or in your book chapter, because you reviewed the practices in energy arbitration in East Africa, what are the challenges, and are there any lessons we can draw from the developed world with respect to improving our arbitration practices, especially in the energy sector? I don't know who's going to answer first, Cynthia or Karen.
I could give one lesson, and Karen could just give another one or a couple. One of the things that we can learn, because what we are trying to do as well is to strengthen our institutions in East Africa, because at the moment we see there's very little investor confidence in local institutions in East Africa, especially for energy and mining disputes. What we can do is, which is one thing that we see the developed world doing, is supporting specific institutions. Because we see there's one popular institution in Paris, one in London. So East Africa is not a big region. If all the countries could rally behind one of the institutions, because at the moment, almost each one of the countries has an international arbitration institution, to just rally behind that and sort of like build that institution, and in terms of capacity, even professional capacity, and adding professionals, and training people to get training and experience in mining and energy, so that we can build capacity for our institutions as well.
All right, Karen, any comments?
Yes, maybe to add to that, I think the developing world is understanding the significance of energy and mining, and our developing countries are yet to understand the significance of energy and mining and the role that it plays. Their awareness of the role that it plays allows them to, when it comes to dispute resolution, it allows them to create specific components, like Cynthia mentioned. They are able to create specific institutions, and in this case, we see them understanding that energy plays a key role, and they need to create a support mechanism in terms of how investment is handled, in terms of how commercial agreements are handled, so that we are able to understand the impact and the dynamics behind energy and mining, so that each component, well, right from the concept of negotiating these different agreements and these different arrangements, commercial arrangements, let's understand the unique nature of energy and mining, so that when these disputes arise or when these challenges arise, we are able to resolve them for what they are, not what they could potentially be.
All right. So I think we don't have any more questions. Yes, we don't have questions. Thank you very much, Karen, and thank you very much, Cynthia. So let's just have the closing remarks from both of you, and then afterwards, this will be the end of our webinar. I'll start with you, Cynthia.
Thank you so much, Dr. Nalule, for this opportunity and for giving us a chance to just speak briefly about our chapter. I really look forward to what the industry is becoming both in my country and in the larger East African region, with the creation of the East African Power Pool. And in the mining industry, I'm at least fortunate to have taken a bit of training on mining, and we are seeing the mining industry is really coming up in the region as well. So I'm really looking forward to seeing looking forward to the future and seeing how the industry will grow. And I'm also encouraging everybody to look forward to our chapter. It gives very detailed insights into these disputes. We give summary of all the disputes handled in international arbitral institutions in each of the East African countries, or all the countries that are part of the East African community. So I urge everybody to look forward to that as well. Thank you so much.
All right, thank you, Cynthia. Karen, your closing remarks.
I look forward to seeing the sector grow, being part of the growth of the sector and providing support to not just my country, but to the greater East African community. And I'm excited to see that energy and mining is something that is at the forefront, and we're seeing the countries putting their best foot forward to ensure that there's stable frameworks and stable structures to support the industry. So I look forward to seeing it, and I'm happy that our book chapter is coming out at the right time. It's coming out at the right time when we can provide our insights and provide a path to show the trends that energy and mining disputes have taken, so that we can grow and learn from them.
All right, thank you very much, Cynthia. Thank you very much, Karen. This marks the end of our webinar, and as you've heard, this is part of a book project. titled International Arbitration in the African Energy and Mining Sectors. It's a book of its kind, one of the book of its kind, in that it's the first book which basically looks at arbitration in the African energy and mining sector. And we're expecting over 50 chapters from different experts throughout Africa, but also outside Africa. So be on the lookout for this book project. And it's a live book in that each chapter we get, as soon as it gets ready, it will be live on a special platform, Power platform. So thank you, Cynthia. Thank you, our viewers. Do not forget to subscribe to my YouTube channel, Dr. Victoria Aranalole, for more videos with respect to energy, mining, but also international arbitration. And obviously, you can always look out and connect with Cynthia and also connect with Karen and be ready to read their book chapter. This marks the end of our webinar. Thank you very much all and have a lovely evening. Bye-bye.
Bye.